everyone. My name is Salem Nasser. I'm an international law teacher here at the school and the coordinator of the Center for Global Law. So at this moment, we will thank each other and each one of us many times. So now I begin thanking you for coming and speaking in the name of the school and our dean. For your presence, and obviously we thank Franco for this joint organization and joint initiative to discuss this this very important subject that has just undergone a very important moment in our Brazilian legislative and trade history. So this is a very good moment to have this discussion here. Of course, I begin talking because I'm supposed to talk a number of minutes during this debate. And since I don't know much about CISG, I have to spend some of the minutes thanking and, and introducing the event. Of course, we thank very much Rafael Alves, who has been at the forefront of this initiative and has made this possible, has brought this idea to our school to have it done with us together. So I thank him. I will give him the floor right away. So he will preside the work of this first panel. Welcome.
Thank you, Salim, for your welcoming remarks on behalf of FGV. First of all, I would like to, of course, the thank you part. I would like to thank FGV and the Center for Transnational Litigation and Commercial Law of NYU for co-hosting this conference today. I think it is a great privilege and a great pleasure for us all to be here at this conference. And of course, that would not be possible without the sponsors, our 5 sponsors in this conference. So I'd like to thank particularly the law firms which sponsored the conference, Machado Meyer Advogados, Barbosa Musnick Aragão Advogados, Grebler Advogados, Nasser Advogados, e Luislavo Batista, Schmidt Valois, Miranda Ferreira Angel Advogados. They made this possible, so I'm really grateful for their help and their support. Of course, Professor Franco Ferrari and also Professor Pilar Perales, who took their time to come to Brazil. I know they have very busy schedules. It's not easy, particularly during this time of the year. I know that Franco, for instance, has to go back to New York for a conference on Wednesday. So I know that he's been here, struggling with this. So thank you very much, Franco, personally, for your presence here and all the arrangements I had to make to be here. And also, I'd like to talk to the speakers of the conference, all the speakers. I was a witness of their preparation throughout the previous weeks. I was copied in all the messages they exchanged. And it's really great to see the amount of work they've put in their preparations. And I'm positive that this conference will be very productive. The amount of messages exchanged before the conference tells me we're going to have some very good discussions throughout the conference today and tomorrow. Just to give you an overview of the conference before we start with Professor Franco Ferrari, the idea of this conference is to try to provide or facilitate some sort of a comparative analysis between the Vienna Convention and our own law, Brazilian law. The idea behind it is that it's easier to understand. Maybe it's easier to understand at this point where we are now, Brazilians, the Vienna Convention, if we try to better understand the relationship between its concepts and categories relating to our own civil law or sales law. Of course, the idea is not to give a Brazilian perspective of the CISG. We'll be discussing tomorrow morning how important it is for the CISG to be interpreted uniformly and transnationally, meaning the idea is not to have a domestic perspective on the CISG, of course, because that would not work. The goal of the convention is to foster legal certainty. So if each country started to look at the CISG by its own concepts, that would not work. Still, we believe that this comparison between the Vienna Convention and our Brazilian law could help us identify where we are heading to, and what are the difficulties we have and the challenges we have ahead of us. So that's the main framework of the conference. How is it structured? We start today with a very brief introduction on the CISG, its history, its origins, its purposes by Professor Franco Ferrari, with Salim Nasser debating. Then we have a roundtable just after this panel, where we discuss basically the applicability of the CISG. It's a very difficult subject. I had the privilege of taking Professor Ferrari's course at NYU, and we spent, I would say, most of the course discussing Article 1 and Article 2. So I thank all the speakers of this panel who are here today who have accepted this task of discussing the applicability by the judge, the Brazilian judge, and arbitrators, in especially, particularly Articles 1, 2, and 6 of the Vienna Convention. This is all for today. I don't want to keep you here until midnight, so it's all for today. And then tomorrow we start, again, discussing interpretation, as I mentioned. And then we have 3 panels where we discuss specifically these some topics. Formation of contracts, sellers and buyers' obligations, and then breach of contract, mitigation of losses, remedies. And after that, we have a final roundtable, which I think will be very interesting, where Franco, Professor Pilar Pelares, and other Brazilian colleagues, Nadia Araújo, Adriana Dantas, and Flávia Bittar, will be discussing recent case law on the CISG. So we have brand new decisions. Some of them just came out, I would say, weeks ago, to discuss with the audience. This is pretty much the overview that I had in mind to give to you. Of course, you came here to see Franco talking, not me, and all the other speakers. So I'll give him the floor immediately. I would just like to introduce him briefly before I pass the word to him. Franco is a full-time professor at New York University School of Law, and he's also the director of the Center for Transnational Litigation and Commercial Law, who is co-hosting this conference. Actually, Franco was kind enough to also advertise the conference at the center's website, so everyone out there is also looking at the conference here right now. And apart from being a full-time professor, Franco also is very often consulted as an expert witness and to issue expert opinions, and has also been appointed several times as arbitrator in many international arbitrations, including a recent exit case, which I can tell because it's public. He has been just appointed on a very important matter involving Venezuela and Spain. So again, thank you, Franco, for your time, for your effort to be here with us. I hope that the conference is productive and we all can gain with that. The floor is yours, please.
So thank you very much, Rafael. But of course, I too have to thank FGV, of course, and all the 5 sponsors whose name Rafael already mentioned. I don't want to hurt anybody's feelings if I mention those names in Portuguese, so I don't just, the 5 sponsors listed here, okay? I don't want to hurt feelings. So thank you very much. But above all, thanks to Rafael Alves. He is very kind when he says we did co-host or we are co-hosting this event. It was very easy because he did all the work and asked me whether I can advertise it. That's an easy yes. And I make it look like it's really difficult, but it was not. So thank you very much for doing this. So I will talk 20 minutes, and as my German accent should tell you, I will talk 20 minutes. So that's okay. Then I'm happy, however, to take a lot of questions and discuss, of course, any matter that Salem wants to discuss. I think you get much more out of that than of me talking for a long period of time. I can be really boring after 20 minutes. That's why I have to cut it at 20 minutes, okay? So I'm supposed to talk about the importance of the CISG in international trade and what's the significance of the CISG. So there are two different matters. As far as the CISG significance overall is concerned, that's an easy thing to talk about, given that there are today 79 states that did ratify it. 78 entered it into force. One is waiting for the vacatio legis to be over. That will happen soon. Apparently, 78% of world trade is going through the CISG, or to say it differently, CISG is supposed to be applicable to 78% of world trade relating to movable goods. Whether these movable goods are animals, there are cases on that. Whether these are weapons, there are cases on that. Pharmaceuticals, hardware, or all kinds of things. Whether the goods you sell are new or old. Whether the goods you sell are being produced, have been produced, or have to be produced. So these are the issues, and I think that's an easy one. I want to focus more on the second part of the question. What is the significance of Brazil's adoption? In my opinion, the answer is contradictory, at least at first sight, because in my opinion, everything and nothing changes. What do I mean? I know that we will be discussing, at least during the last roundtable, issue of excluding the CISG. The CISG, in my opinion, is a success because of Article 6. Article 6 of the CISG, which I do not dwell into now, but I have to mention it. Article 6 of the CISG is that provision that allows the parties to get out of the CISG. That's exactly what I meant when I said that in Brazil nothing has to change if you don't want it to change, because you can insist on excluding the CISG. So today you have a tool that allows you to actually do things the way they have been done for the last decades or centuries. Of course, that is also, in my opinion, a means for the lobbies to sell the CISG. In the US, the CISG was not welcomed by all trades concerned. In the beginning, we're talking about the 80s, mid-80s, a lot of lobbying against the CISG because everybody in the US believes anyway US law is better than everything else. It's not that the US English people believe wrongly the same. And so the idea was that these lobbyists did lobby against the CISG. The legislator had an incredible, easy means to sell the CISGs to those who were against the CISG. Article 6. If you are a trade association and you dislike the CISG, as a legislator, you tell them, why don't you suggest to your associates to actually exclude the CISG? This is a means to sell the CISG, basically, as a legislator. Because you tell them things can go on the way they were going on for the last decades. You can exclude it. That's one of the ways to see it, which is why I mentioned in the beginning, I believe that nothing has to change unless you think it's a good thing to change. I believe it's a good thing to change. But again, that's my view. It's correct, obviously, but that's different. Okay? So why can everything change? When the CISG will enter into force, CISG in this country, as in every other country, the problem is the US judges don't realize it, the CISG is a default law and is applicable ex officio. Meaning, in my opinion, the CISG is drafted in a way to allow for the judge to apply it, actually to impose upon the judge to apply it ex officio, irrespective of whether the parties actually have pleaded the CISG. I don't want to talk too much about the next part, but still this is, in my opinion, important, also to show where US people get it wrong. Even the French Supreme Court, and they're not really perfect normally, even the French Supreme Court believes the CISG is applicable ex officio. So that's the first thing you have basically to sell. course, domestic law may come into play. Domestic procedure law, which the CSG apparently does not deal with, in my opinion, it does on this matter. Let's suppose you plead on the basis of a law, Brazilian law, in front of a Brazilian court after the coming into force of the CSG. And the opposing party from Brazil, admitted to the Brazil bar, obviously, because otherwise it would not be allowed to plead in front of a Brazilian judge, will plead also on the basis of Brazilian law and Brazilian law only. Now transfer this hypothetical, which is not a hypothetical, to US courts. According to US procedural law, US courts cannot decide on the basis of the CSG an issue when the parties have not pleaded the CSG. There's even worse case law, we'll talk about it tomorrow evening. That's procedure, I can live with that. In my opinion, the CSG is drafted actually to overcome even this procedural rule. Because if it's applicable ex officio, like for example, the German Supreme Court says, the Swiss Supreme Court says, even the French Supreme Court says, then as a party, you don't have to plead it for it to be applicable. Do you see the difference? So in my opinion, even so, under US law, this would be a US procedural issue. Since the CSG covers it, it would override even this issue that's a procedure issue. US courts do not agree, but to me that doesn't mean anything. Okay, so also, what do non-US courts do on this exact issue? As I mentioned, French Supreme Court says expressly, as do other courts, it's applicable ex officio. That means you don't have to plead it, or as a judge, you can take a decision irrespective of whether the parties pleaded. All Italian court decisions, at least the good ones, meaning excluding those of the Supreme Court, are all based on the principle iura novit curia, meaning none of the parties ever did plead CSG, and the court still applied the CSG, to the party's surprise. In my opinion, this is possible due to the CSG itself, irrespective of the principle iura novit curia. However, it is for sure possible due to the procedural rule iura novit curia in certain countries. So this will have an impact here, according to whether your courts will actually consider the CSG applicable ex officio, then the parties pleading can only amount to getting out of the CSG, or not, meaning whether you have or not the principle iura novit curia. So that has an impact. What else will change? Brazilian law will, starting the day of the CSG's coming into force in Brazil, be applicable more often than it has been up to now. Let me explain what I mean, and allow me then to say that that will give you a lot of more certainty, and I also believe it will reduce costs, but we'll deal with that maybe in a question and answer period. So you have a contract today, meaning at a time when the CSG is not in force yet, with a party from a CSG country. Brazilian law can only be applicable if either there is a choice of Brazilian law, which would require, of course, the Brazilian party to be economically more powerful than the counterpart from abroad. And also, more often than not, if the courts are Brazilian courts. So the chance that you get to Brazilian law in an international contract are limited to the cases I mentioned. More often than not, you need to have a client who is economically powerful to impose that choice. Now, let's suppose even that you say, my client is maybe not the most powerful party, but at least as powerful as opposing party, meaning ultimately neither Brazilian law will come into play, nor the foreign party's law, okay? That happens very often. You choose a neutral law. I'm not sure you should choose. That's an insider joke for some of us, Dutch law, but that's different. But let's say you choose a neutral law. Let's say even Dutch law, French law, German law, Swiss law makes sense. Austrian law makes sense because you have a lot of east-west disputes in Austria, north-south disputes, so a lot of these options. But today, any choice of foreign law means just that. It's a foreign law. Do you see that? For a Brazilian party. Whether it's, again, Chinese, US, German, Swiss, or whatever law. Tomorrow, after the coming into force of the CSG in Brazil, even if you choose any of the laws I mentioned, you are choosing, as we know, we'll talk about that, also CISG. Swiss law is at least, for the international contract, CSG and so forth. What does this mean? It means that the lawyers involved at least know part of the foreign law, to the extent that the CSG is applicable, even as part of foreign law. Do you see that? So your law, Brazilian law, read CSG in this case, will be more applicable much more often than it is today, with all the consequences that can come into play once you know which law is applicable. Of course, we know there are a lot of gaps in the CSG, that the CSG deals not with all the problems. We'll hear that tomorrow. That's not the point. But you see, the starting point is completely different. You can be sure that tomorrow when the CSG will come into force, and you as lawyers have to be trained in that law, your law will be applicable more often than not, without any doubt. So that, in my opinion, is the biggest change. It will push courts and you lawyers to actually learn about the CSG. You can make an informed choice on whether you want the CSG or not. That is my problem. So I started with Article 6. It's a selling point. It's a good way to sell it to everybody. Please, if you don't like the CSG, hey, it's good. You can go out. So don't oppose it, because it's just enough to get out of it. The next problem is, of course, knowing about the CSG. Of course, as I said, any foreign country's law where the CSG is in force makes it easier for you to apply your own law, meaning read CISG. The problem is to know when to opt out. I will not talk about what the court says, because we know that we'll talk about that, so I don't want to infringe upon the turf of somebody else. But let's look into whether you should get out of the CSG or not. 2 real-life stories. I gave CLE credits in the US to counsel and in-house counsel, hosted by one of the biggest companies that are in the world. So I have the CEO sitting there, 143 lawyers in the audience. I do my thing on the CSG. I make them laugh a little and so forth and so on. Okay, at one point, I get to the issue of interest rates, and Professor Perales, who also wrote on it, knows that I like that. It's a very important issue to me. So I say what the CSG says, just to tell you, the CSG allows for interest rates. The CSG has the best rule in the world, because it says you are entitled to interest as of the moment of non-payment. It's different than in a lot of countries, because in a lot of countries you have to give notice first. This is the case I'm mentioning here. So I tell them, and then the CEO says, no, you're wrong. Oh, wow. I hate anybody saying I'm wrong. Be a non-lawyer. I mean, okay. But he has my check in his hand, so I can live with that. Okay, 1 no I can live with. Okay, so I swallow, and then do my thing again. Oh, very nicely. I have to kindly disagree. And then I say again, and he says, no. Second time. So I said, look, that's enough. Even my money, who cares? I said, look, you do airplane engines, I do the law. Dead silence in the audience. This guy gets up and leaves, and my check goes there. So everybody quiet. I've never seen a room with lawyers that quiet, because normally somebody's playing on the phone. No, serious, it's quiet. Okay, so my voice gets a little strange, and I talk on. This guy comes back. So we have a break, and he says, you see, I'm right, and shows me the contract. I told him, I'm right always. The problem is you are only right because your lawyer was stupid enough to exclude the CISG. Therefore, and agreed to the choice of an Eastern European country's law. Therefore, you may be right, but not because the CISG says so. So we talked during the breaks, what should we do? I said, sue him. I'm a nice guy, as you can see right away. Sue him. Okay, this is what you say in the US anyway, sue him. Okay, so this person calls him, and the lawyer was in the room. So lawyer comes and says, oh, you did exclude the CSG? Oh, yes, and so forth. Okay. Ultimately, it was solved in an arbitration. Sole arbitrator, the hearing lasted 10 minutes. Because this stupid lawyer did give the most stupid answer to a very easy question. why did you exclude the CISG? A, I'm allowed to by virtue of Article 6, and I don't know the CISG. Great, but you know Hungarian law? I mean, do you see where the problem lies? Believe me when I say, CISG Article 6, in my opinion, is the most important provision. There's no other provision like Article 6. You can get rid of it fully, you can derogate, all the stuff we'll be talking about in these 2 days. It's the best thing. You have to know when to exclude it. That's what I would say. And I will suggest to those of you who counsel clients, there are various tests. For example, in my opinion, the potentially bad seller, and statistics show the seller is potentially the bad guy, likes the CISG, loves the CISG, wants to stay with the CISG forever. Let me give you 2 reasons why. CISG has a rule, and we'll talk about briefly tomorrow, that's why I will be very brief. I give you summaries, that's what I was asked to do, and I'm happy to expand during the question and answer session. The CISG limits damages a priori, not to what you all know, direct and immediate damages arising out of a breach of contract, no. It limits damages to foreseeable damages. Actually, damages foreseeable by the breaching party at the time of conclusion of the contract. I wonder, I dare you to find a rule that is better than this. Because you are the bad guy, and potentially you don't have to pay 100% of the damages, but only those that are foreseeable. Normally less than 100%. Do you see that? So that's a good thing. Statistics show that normally it is the buyer who says or alleges that there is a problem with the goods by the seller. It makes sense. You don't have to be a lawyer to understand it, because the seller is somebody who either produces the goods or is somebody who resells goods. So the control the seller has over the goods is never the control the buyer has over the money. Do you see that? So there may be a problem in the production process of the goods, there may be a problem in getting the goods in time, and so forth. So the risk, in my opinion, the seller runs are much higher than the risk the buyer runs. Because the buyer has to know, does he or she have the money? So it is unsurprising that more often than not, if you look at existing case law, it is the seller who potentially is the bad guy. Okay, so we saw the seller like CISG Article 74. Seller is normally also the creditor of the purchase price. So if it is true what I mentioned earlier, that Article 78 is really the best rule out there because it does not require you to give notice of the default, and it does actually allow you to interest as of the day of non-payment. If you have to pay on October 10th, and October 10th has passed, it's 0 midnight, meaning of October 11, you start to interest on it. Do you see the difference? So you can see why it is incredibly bad for somebody, like in the hypothetical I mentioned, who is selling goods that potentially are rather dangerous, airplane engines, and excludes the CISG, and opts for a country's domestic law that has a rule on damages that is different, not as good to the bad guy, meaning read seller, and has a rule on interests that is completely different because it required actually a notice. In this case, interests in 62 days was $8.2 million. Just the interest. You don't have to prove anything. You just tell us, dear debtor, you did not pay in time. There's no need for you to show that you have damages due to non-payment. Nothing. You can interest. At that time, we're talking late 90s, the interest rates in Eastern Europe were very high. So for 62 days, you just sit back and get $8.22 million. This is what you have to know, in my opinion. So I would suggest that it is not as easy to opt out of the CISG. There are some nice tricks, we may get there and so forth. But for a seller, statistics show that allegedly it's a seller normally who's a bad guy, I would suggest not to a priori exclude the CISG. This is something you will have to see. You will have to compare it with your domestic law, whether your domestic law is better or not. But I cannot imagine that Brazilian domestic law has a better rule on damages for the bad guy than the CISG. The CISG rule is different even from French law and even from Italian law, where we have this foreseeability rule. We have it for 2 centuries, basically. So Roman law, in Roman law, it existed already. Why do I say that? Because the rule applies only in these 2 countries if the breach was non-intentional. The CISG rule apply also when there's an intentional breach of contract. So foreseeability applies. So, you know, this is incredible. This is something completely new. This is, in my opinion, what you have to do. Which is, again, why I believe that everything changes and nothing changes. Article 6, in my opinion, is the rule you have to know most, because it is the one that allows you to do business as usual or to actually change things as they should be changed. And I see my 20 minutes are up.
Thank you.
Thank you.
Thank you, Professor Ferrari. I will pass the floor to Salem directly.
Well, thank you, Rafael. Now is the time I show my ignorance. So I have started to wonder about this discussion, taking as a starting point the questions. What is the importance of the CISG for international trade? What is the significance of Brazil's adoption? And I automatically thought of ways in which we could think the answers to this. In some part, you have gone another way, different from what I had thought. And in some things, you have touched upon what I would imagine. Let me put it, let me say first what I think you did and what was my imagination before. I think most of your talk dealt with why CISG is a better law, right? Why is it a good law? So your comments, for example, on the opt-out clause, on the interest rules, on damages, on why it is better for the bad seller. So basically, I think you were dealing with the normative contents of CISG, and I don't know, I felt that maybe addressing an audience of lawyers, telling them this is why this is a good rule, this is why it will be good for you, for your clients, right? Only marginally, maybe, you touched upon another type of quality of the rules, of type of quality of the CISG itself, which is its harmonizing effect, right? So this is also a link to the quality of the CISG, but it's not about the rules, interest or damages or who does it protect, etc. It's not that it's a well-drafted law. It is the fact that it will be the same for most people that will apply it. So this is in itself something good. It is a quality, but it's a different kind of quality, right? So this would be a different type of effect, right? A positive effect. So the first one is, well, the rules are better, okay? This is a positive effect. This is good. This is why it's good. This is why it's good to have CISG approved by the Brazilian. The second is it's good because it's harmonizing. It has a harmonizing effect. But there was a third possibility that was what I thought most of. That is, it is good because it's good for business, right? So what will be the effect on business, on the number, on the amount, on the increase of business, right? So, and I have understood actually both questions in this sense. Of course, you have touched upon this at the very beginning when you say as well, this is the number of countries that are parties to the convention, and this is the percentage of world trade that goes through. So usually, well, this is the basic starting point. Why you justify CISG? It's okay if you have 80% of trade that is ruled by it. It's better to. I actually was wondering, this is a school in which we trust a lot empirical work, right? Not myself, I suck at it actually, but my colleagues do a lot of empirical research in law. So I was asking myself, how is this supported empirically, right? And of course, why is it good for Brazil in the sense that having CISG will be good for Brazilian business, will be an increasing factor, something that will help increase Brazilian business, right? Of course, there is the easy answer. It's harmonizing effect. People will be more sure, etc. But maybe something beyond that, right? So, as I was trying to imagine the answer to this, and this is why I say I'm always trying to understand. I told you before, I have been called to speak on CISG or to debate on CISG more properly for maybe 3 years now. And I'm only curious, all the time curious. So my curiosity this time is spelled out like this. How could I imagine the answer to this question? How will it be important or significant that Brazil has adopted it for Brazilian business, right? And of course, with my concern towards empirical data, something that we can support the answers with. So I immediately thought that these answers will depend on a series of variables, right? And this may be very basic for whoever works very closely with CISG, but I had made my own list of variables, right? Of course, it starts with the very basic information. The number of states signatory to the convention and who are the states, of course, right? Who are the states and how much of the international trade does this cover? But of course, there is a second variable that is at the very beginning of the convention, that is the sphere of application, right? And it is the fact that, well, if both parties to the contract are not from signatory states, only if the rule of private international law indicates the CISG as applicable, because it indicates the national legal solution that has incorporated CISG. I think that here these are two very important variables. I don't know how much it really is, but I think there is a question here, specifically, more importantly, with the private international law rules that will indicate. This, of course, is very important for the Brazilian case, because our conflict rule concerning contracts is still, it's not even the choice, the party's choice, so it is the place of celebration, the place in which the obligation was born. So this, I think, could give you, I can imagine a set of possibilities that will open up, and then you will have uncertainty where you are supposed to have only, I don't know that there is a solution, but I'm thinking of this not as a problem, but as a variable that will impact on the significance of the convention for trade, right? And of course, there is the other variable that is the role of judiciaries, right? Of course, one first role of the judiciary is the way it sees the conflict rule, right? And the second is the interpretation. So the interpretation of the rules of CISG itself. There are two variables within the work of the judiciary, how they deal with private international law and how they will interpret the normative content of the and also, one thing that you have presented as a quality is another variable. It's the opt-out clause, in which opens a new possibility of variation, and also because it has some possible implications with the private international rule, right? Because, for example, will Brazilian judiciary take into account the opt-out clause when it comes to the conclusion that it has to apply the law of a country that has CISG as, since we don't even accept the choice for the law applicable, will we accept it for the opt-out clause? It's at least imaginable that some judge will think that this is actually. So I'm asking myself specifically, and this is maybe this is a complementary or supplementary question, but basically my question is, how do we gather enough empirical information on how this impact will be concerning all these variables? Does, for example, your long practice with CISG give some indications of how this goes with other countries in terms of, or you can tell me just, well, all these variables are not so important, right? They are imaginable, but they are not important in practice, etc. So I think this is the basic provocation that I would make. And taking this into account and specifically, so taking all these variables into account, does your statement that it can really remain the same, does it still stand? Do you think it really can remain the same? Because you said the opt-out clause is one guarantee for your clients, for example, that if they want, everything will remain the same. Is it really true only because you can opt out, right? I don't think so. But okay, this is only an intuition.
Here's where the fun starts. Okay, I had to give the spiel I did earlier, but now it's really interesting. Okay, let's start with the very last question first. It's an easy one to answer. Yes, things can remain the same. But let me go through the various elements you referred to. When I said the better law, I actually meant, in this case, for the seller. Now let's put ourselves in the shoes of the person buying the airplane engines. I think the lawyer for the Hungarian parties that did buy those engines did a great job in insisting and getting Hungarian law in, because its client did not pay $8.22 million. So whether it's a better law vis-à-vis your own law, it's something you have to measure. I'm criticized wrongly by some colleagues for actually distinguishing between the seller's rules and the buyer's rules. A lot of colleagues say, oh, you can't make a distinction between the CISG's rule on the buyer and CISG's rules on the seller. This is not what the CISG does. That's not what I am doing. Because we're talking about opt-out. So I'm comparing the CISG's rules on the buyer with the otherwise applicable rules on the buyer, meaning if the CISG doesn't apply. So this is something I suggest you do as a lawyer. I'm only saying that when you decide whether to get out of the CISG or not, there are some very general statements one can make. Probably that the CISG is good for the bad seller. It is not as good for the good buyer. The good buyer wants to get out, because a good buyer generally is actually the debtor of the purchase price and hates Article 78. If statistics are correct and say the seller normally is a bad guy, it means, statistically speaking, the buyer is a good guy. If the buyer, statistically speaking, is a good guy, the buyer hates Article 78, 74 as well, because the buyer wants to get 100% of the damages that occurred rather than the foreseeable ones. So that's one thing. So better law may be for certain instances. The next point, the harmonizing effect. I like the harmonizing effect. So you are completely right. I did not express that. I do make a living out of uniform law, so I love uniform law. In doubt, it's always okay. But there is actually a problem. And this goes to whether we can measure things. Whom is the CISG addressed to? A lot of colleagues say, oh, the CISG addressed to the parties, you read preamble, and so forth. No way. Why do I say that? In many countries, small and medium-sized enterprises will not run to the lawyer prior to the conclusion of the contract. If that is true, then I wonder whether the players, the economic players, the enterprise, really knows about the CISG harmonizing the law in 78, soon to be 79 countries. Do you see that? So I do believe the addressee of the CISG rules are normally not the enterprises. If at all, they are the judges, and sometimes the lawyers, but only where the lawyers come into play prior to the conclusion of the contract. So harmonizing effect, yes, I would say still you have to consider that the addressees, in my opinion, are not the real players, but if at all the lawyers, for sure the judges. So leveling the playing field, things you read about a lot, CISG does that, it's great. It's not really true if you don't know about it. Is it good for business? Is it good for business? I would say yes. Is there empirical data? Not necessary, but let me tell you. The sheer number of contracting states means something, meaning contracting states or states want to become contracting states, otherwise they may be out of certain kind of business. Their courts will not be chosen maybe as the courts where to start court proceedings. Their law may not be chosen in order to govern a contract because it's not a CISG country. Also, statistics show that all of the countries that did make reservations, because that's also possible under the CISG, are attempting to get rid of the reservations. So that to me means something. Even those countries like Sweden, Denmark, Norway, and Finland, they had to make reservation to Part 2 of the CISG, to formation, because they wanted their law to prevail. That's creating, even to them, so much certainty that all of them have denounced the reservation to the UN Commission that is basically the depository. So to me, that may mean actually they have experience. They see that something is not working really the way it should. We get rid of that problem. So that's why I think it is actually good for business. It's good for business because you will be considered as a country where the CISG is enforced. That by itself, in my opinion, is something you can use to sell. You know, statistics show that for direct investment, there's a recent law review article in one of the law reviews I dislike a lot because it deals with what you said, law and economics. I'm at a school where everybody does law and economics. You want to buy a cappuccino at the cafeteria, I think they do law and economics. I don't. You know, I do real life law. So, but that apparently says that there is proof that a legal regime that is more uniform in substance, which we're talking, and in securing, guaranteeing certain investment, meaning BITs, is helpful and attracts business and money, foreign investment. So if you believe them for once, that would be an argument in their favor. Also, the states, you said, you know, basic info is important. What states? I normally do not have a tablet on, but I do that for a reason, because on this page, actually, I looked up the 2010 Brazil's trade numbers. Let me give you very briefly. The number one country, or in this case, system of countries, from which Brazil imports, these are the most recent numbers I have is 2010, is the EU 27 countries, which amounts to 21.9%. All but Portugal, England, and Malta are actually contracting state to the CISG. Number two importing country from whom you import is United States, 15.3%. China, Argentina, and South Korea. All of them are CISG countries. If we look at countries to which Brazil exports, they are EU, number one, China, United States, Argentina, and Japan, instead of South Korea, is also a contracting state. So I would say it makes you part of a group where the CISG is enforced, and by itself, in my opinion, that makes Brazil, like all the other countries, look a little more manageable. You know what's going on. Okay, so not only the advantage that Brazilian law applies very often when foreign law is chosen because of the CSG, vice versa, I would say, as well. Now, of course, you're right. The CSG will be enforced either when both parties have the place of business in contracting states, and the court is one of a contracting state. May even happen if it's a non-contracting state, not the issue here today. But then there is 11B, obviously. You're right. 11B is a non-issue as far as choice is concerned in Brazilian courts, the way I understand it, because there's no free choice. Some people believe there's a limited choice, but it would have to be the choice between either the countries where the parties are located or place of performance. But otherwise, the way I read Brazilian decisions and Brazilian commentators, it would be, as you said, place of conclusion of the contract, maybe the place of the seller, and so forth. But that will get you, in my opinion, to Brazilian law. So that would be CSG anyway. But you're right. 11B, together with Article 6, may create, of course, some problems and uncertainty. But always think of the alternative. The alternative is no Brazilian law, because you can't be sure that you get to Brazilian domestic law. That's my point. Problems, yes, all the ones you mentioned I would agree with. I'm only saying the alternative is not CSG at all. Or CSG is still applicable somewhere, but if you had not entered it into force, it would mean to you, oh, that's really foreign. The day it comes into play in Brazil, you will have to know it because it's Brazilian law. So that's why I think there is an advantage there anyway. Now, what about statistics? Again, there are no statistics. I still believe that you save money. Because if you are a big enterprise, and again, I refer to those because medium and small enterprise may have different problems. They don't go to the lawyer early. So now you are pricing. You have to price your goods. Okay, this good is X. Okay. What if you can apply Brazilian law or CSG, as you now know it, or foreign law? You will have to actually ask for opinions, and this is what the big ones do probably, as to the foreign law that is potentially applicable. If it's Brazilian law, or at least something that is also part of Brazilian law, I would say the costs are being reduced. I'm not saying you should not go outside to outside counsel. I'm only saying you will know more about the law that will be applicable because it's also part of Brazilian law than not. So these are the only things. But if you were to ask me for statistics or empirical data, I can very well live without that and still believe that it is beneficial.
I'll ask a question for both of you. Maybe Professor Franco could first answer, and then Salen could comment as well. I would like to insist on this topic of measuring the CSG impact, because this is what we'll be dealing with in Brazil from now on. As you are aware, Professor, the timing of this conference is very good because the Senate has just approved the CSG text, and now there will be, as always happens with Brazil, people will discover the CSG, and people have many questions about the CSG. And I had the experience already with by talking with journalists. Not that I want to make our debate here oriented to media concerns, but I think they have a good point in terms of selling out the CSG. And they always keep asking me, okay, I understand the uniform law, the legal certainty, everything, but could you give me a concrete example of a Brazilian company doing business abroad? How would that change in their lives? I mean, how much money they would save? And we had this discussion. It's very hard to measure. But I was thinking while I was hearing your comments, and I wanted to, would like to ask you that. Okay, we don't have empirical data. It's very hard to measure to what extent the CISG actually helps companies save money, on one hand. On the other hand, you have mentioned two very important aspects, limitation of damages and interest rates, which have a direct impact on price, right? So either we cannot measure at all, or maybe council are not doing their job, not only in terms of deciding to exclude the CISG totally or partially or not, but in their negotiation, when they're negotiating a contract, maybe it's our job as lawyers to say, look, okay, you want to apply CISG, I'm the buyer, I have these problems, I have these issues. I cannot claim, I can only claim foreseeable damages from you if you default. So that will have an impact on the price. So on one hand, we cannot measure, definitely we don't have empirical data. On the other hand, I don't think we are doing our job in terms of negotiation, because these issues that you just mentioned, they have a direct impact in the price. In the end, I have to pay more or less if something goes wrong. So I'll go to my question. That is, I'm just talking and talking. My question to you is, could you please help us identify those? You mentioned two, limitation of damages, interest rates. What are the other issues of the CISG which have a direct impact on the price, and maybe we lawyers, internal counsel and external counsel from companies, should start doing their jobs in terms of negotiating the contracts? Again, I'm not discussing just opt-out or opt-in, but if you want to keep it, that's the price. You have to pay this price. Or maybe let's exclude limitation of damages. Let's apply Brazilian law for that. Let's just discuss the other aspects of CISG. So there is a room, I guess, for this type of engagement in terms of, if you want to measure it, let's start discussing the effects on the price, right? And I would like, to, of course, to hear your comments, Sally, as well.
So I agree with what you said, Rafael, that you have, as a lawyer that is a transactional lawyer, some CSG rules that may help you to get the price down, or on the other side actually will raise the price. The most important one is the one we mentioned already, actually the rule on limitation of damages, of course. As a buyer, what would you do? And again, believe me when I say this plays only at a transactional level, because otherwise, what you said, I mean, you as a lawyer being able to somehow influence, that doesn't work. It normally works only if you have two big enterprises, unless, of course, you draft the standard contract forms for a big enterprise and factor that in. So first of all, there are some rules that you may like as a buyer, some rules that you may like as a seller. What can you do? In your drafting process, you can exasperate them and push opposing party actually to say, look, this rule is really bad, I want you to get it out. And you will say, of course I can get that rule out, but it costs you. Either because you have to give up your rule number 10 or whatever, or because I want the price to be reduced. So various rules here. First one, the most easy one is form requirements. Form requirements are the best way to push opposing party to certain things. Let me give you a very easy example. I'm the seller and I propose the following clause in my standard contract terms. Any notice to be made within 5 days from the day of discovery of the delivery of the goods has to be given in writing via email, anticipated via telefax, and with registered mail. Crazy. We know it's crazy. But by drawing your attention on this rule, which contradicts normally Article 11, freedom from form requirement, I have done various things. I will probably push you to opt for one of the three means I mentioned. Email is enough, or we can say one of these alternative means for notice has to be given. So you use one of these. By doing that, I got rid of Article 11 right away in the area of notice. I also try to draw your attention to this ridiculous form requirement and have actually modified Article 39 of the CSG, because I just told you, you have to give notice within 5 days from delivery of the goods and not reasonable period of time of discovery of the defect or moment in which it could have discovered. So there are rules which you can use. So Article 11, in my opinion, is the easiest one. Okay? Let's say the formation of the contract, the rules you have to opt out prior to, not while during negotiations, otherwise that won't work. Then, fundamental breach. You will see, we'll talk about that, of course, as you see tomorrow. But let me tell you that fundamental breach is not something that a lot of countries know. The remedies under CSG Even so, some colleagues believe they have to be distinguished between remedies for the buyer, remedies for the seller. Nonsense. The remedies are remedies that are triggered by fundamental breach or remedies that are always triggered. That's the distinction to be made. Some countries don't know it. Some countries have the perfect tender rule. That allows me as a buyer, if I get 100,000 t-shirts, or if I order 100,000 t-shirts and I get 99,999, to terminate the contract. Even if I get only one, if I don't get one t-shirt. So that's a perfect tender rule. What does it do? It allows me to speculate. It allows me to speculate because let's say the price went up, then I don't want them anymore. Or I want them, but I don't want them if the price went down because I can get them cheaper somewhere else. So CISG fundamental breach rule, in my opinion, has to be factored in. You can get out of the contract only under certain circumstances, not as easily. Maybe that's what you want to factor in. What kind of remedies do you have once the breach is not fundamental? Damages, we mentioned it already, so that's something you have to factor in. What about other damage? Specific performance. Oh, specific performance is a general remedy under CISG, but in one instance. But normally it's a general remedy. Okay, you want to factor that in. You maybe want to give it up. You see, it's not only positive. You want to give it up, you say to the other party, you give me something. Transfer of risk. Transfer of risk rules, of course. The default rules is transfer of risk occurs with handing over of the goods. You want them earlier, you use a Incoterm, fine, you pay. In real life, these guys don't know what they're doing. I mean, they conclude the contract. Somebody's calling you up and say, I need spare parts for the machine you sent me last week, or for the machines only you are producing. You will sell them. Don't you think that you know that the CISG is applicable, or that, not even CISG, that the law is uniform? This is the idea the drafters had. We make the law uniform, as you can read in the preamble, and we are creating good relations between nations. It's funny. But that's it. I mean, it's funny. You read it, and when I don't know what to do, I just have fun by reading the preamble. So, but I think there are a lot of provisions that give you ammunition, so to speak, in both sides, to give up something, but it requires you to be a transactional lawyer, to be there prior to the conclusion of the contract. Later, it's much harder.
Well, I don't think I have any specific comment on these answers, but since they are related to the previous arguments, I think well, there are two easy answers for us here in this discussion in Brazil. One is that you make, you and others with you make a very strong case for the logical and purposeful adoption of CISG, because theoretically and logically you can see the advantages of it. So this is very strong. I think that theoretically, and of course, when I was telling you about the empirical data, which I have confessed that I have no familiarity with, but of course, we cannot have it yet for Brazil, unless we want to do something that compares what was with what will be. But I think there is a slim possibility, but there is still a possibility that you will have a better law in its contents. You will have it better because it's harmonized, because you will have better chances to have Brazilian law applied and all that, and have no necessary positive impact on business. I think there is a chance that this could be. So you would say this is good because it's good for judicial policy, it's good for security in business, it's good for predictability, it's good for everything, but it has no impact on business, right? So this is me working again with my understanding of the basic question. Will this be, of course there is a strong case for it, but we will have to see. But the strong case is there. This is one thing. The other thing is, well, it's the fait accompli, right? It's here. We're gonna have to deal with it, right? So it's here. We have to. So in this sense, more than a prediction of the future, of the impacts, my variables that I put forward are things that I think Brazilian lawyers will have to deal with, right? As CISG enters into force and we start to work with it, right? And I think we may discover that many of these variables will start to work in our daily practice, in our judiciary, and they will bring about many problems, right? So there will be maybe an adapting phase or maybe a long period of uncertainty. So my variables were not advanced just for gathering what will be in terms of business, but also they are cautionary notes for the lawyers that are going to have to work with this in Brazil, right? At least in my view.
In fact, just to add, there may be, of course, learning costs. But learning costs are, of course, costs that you incur whenever there's new legislation, whether it's uniform and comes into play now here, or whether it's any piece of legislation. So you are completely right, but everybody knows, I would agree with that. I'm only saying these learning costs will be learning costs you accrue once. I say that because there is no way the CSG will ever be modified. Ever. Ever. In 2001, Uncitral, when I was actually at Uncitral itself, asked me to write a report on CSG and electronic contracting. Because the idea was, should we look into modifying the CSG or adding to the CSG? The answer was, A, do not even think that you can change a convention that at that time was in force in 62 countries, because you would need actually the agreement of all the 60 countries. So that is nonsense, obviously. From the substantive point of view, of course, the CSG applies to electronic contracting, not to electronic goods. That's a different thing. But I'm only saying, you're right. There are some expenses at one time to get things wrong, error costs. They are associated in the beginning with learning costs. Absolutely, yes. Unlike domestic legislation, this is basically something that is set in stone because of the high number of contracting states. So you run into these learning costs once, and that's it.
Okay, I think we're ready to go to the audience and see who has some questions for Professor Ferrari or Professor Salim. Don't be shy. I know we are videotaping, but please, Habib. I think, can I just ask you to state your name, because we are recording, and then...
Well, in order to stimulate the audience, so as I'm from also the house here, I will... it was really very interesting to hear both of you, and of course, many important issues came out, right? I would like to make comments on two of them, and first, the issue of impact on business, of the adoption of the CISG, right? And maybe here we could make a distinction between creation of new business, impact in the sense of creating new business for Brazilian companies, and another effect, which I think is more, probably is more effective, which is to facilitate business, international business by Brazilian companies. And here I give an example, departing from what Rafael said on the examples of these benefits, right? So we have a client that buys commodities from trading companies, right? And many of these trading companies, they have standard forms of contract that they don't accept to change in any way, right? And sometimes they have really good prices being offered to the purchaser, right? and they have their standard choice of law and jurisdiction. Usually arbitration abroad, usually a foreign law, right? And then you have the calculation, and then this company, this Brazilian company, asks, what should I do, right? The price is very good, I'm interested, right? But how can we, what should we change in this contract? And as a lawyer, you would say, there are many things to be changed here, many things to be included. For example, there is no provision whatsoever of what happens if the goods are not delivered in the contract, in the standard form. And the price is upfront, right? So we would like to say what happens, that the amount must be given back, that there should be interest, that there should be a penalty, but we cannot do any of this in some cases in international trade, right? There's no time for that, and it's an opportunity. Either you take it or you lose it, right? So there I see CISG, if it's the law of a country that has ratified CISG, there is a clear benefit, because you can tell the client, look, the rules that will apply are these, right? We don't need to provide for these solutions in the contract because CISG already gives us these solutions, right? Of course, this awareness about what CISG tells us will only increase after we ratify it, right? So even if the choice of law continues to be of a foreign country, we will have more predictability of what the solutions will be, right? So maybe it's a facilitating factor for business by Brazilian companies. This is one comment. The second comment is on what you said about the addressees of the CISG, which I thought was very interesting. I'm one of those professors that tell the students, look, the CISG provides for rights and obligations for the parties, right? Different from other international treaties, it does not provide for obligations for the countries or for governments. It is directed to the parties, right? But it's also true that many companies do not know of the existence of the CISG, and they don't even think about it. So what I think could be said is that this is a case in which countries have decided that this legislation is useful for the economic agents in their countries, right? So it's like any other piece of legislation of which not necessarily those that will be affected by the law participate in its creation, right? But it's the country or the government forming a consensus that this is the kind of regulation we need, right? So I think it is still addressed to the companies, even if they don't know about it, right? Because governments thought that this is a useful tool for international trade, right? So these are the comments I thank you.
I don't know whether you want to ask right now, to answer right now,
yes,
or do you prefer?
Quickly.
Okay.
Yes, so I would agree with your point on facilitation. We see a lot of East-West contracts where the CSG is actually chosen in an arbitral setting, not as much in state courts, let's be truthful. But what you can do in those cases is actually choose an arbitral forum that allows you to choose actually rules of law rather than law, and then you get to the CSG. I've seen that a lot. I'm very much involved in arbitration with Europeans and Asian companies, always appointed by the Asian parties that have a clause that says CSG, nothing else. Then you have to figure out the gaps, but that's a different issue. But I agree it's a facilitator, because there's no way a Chinese company wants US law. No, they prefer not to do the deals, that's it. You know, that's what happens. So that's why I agree with you that it's a facilitator of business. As far as the last point is concerned, obviously you are correct. If the legislator has made the choice to ratify the CSG, your thoughts came into play prior to the decision. Is it good or bad? So you are completely right. Still, you go to businesses and ask, so you apply the CSG all the time? Say, what do I have to apply? To a sticker or something? So believe me, they do not know. That's why I do not believe it's the addressee. The ultimate addressee are actually the parties, the real parties, the players. Yeah.
Lauro.
I'm Lauro Gama from PUC Rio. I would just like to underline or stress one of your comments on the ex officio application
Yes.
of the CISG. In Brazil, treaties and conventions are equivalent to federal ordinary law. Therefore, by virtue of Article 337 of our Code of Civil Procedure, judges must apply CISG ex officio. But in practice, I fear that sometimes we will have a complete ignorance by the parties, both by the parties and by the judge, of the law applicable to the case at hand. Therefore, rather than, or in parallel to this, the ex officio rule, there's a very important role to be played by academia, by lawyers in invoking before the judges the CSG. This is what I found interesting about the ex officio point.
I think just to comment on ex officio, I think this would be interesting to observe whether it is Brazil applying the convention as Brazilian law and Brazil applying the convention as a foreign law.
Yes.
When it is applying CISG as a foreign law, maybe the issue of ex officio will not be justified in the same way. Because there is this controversy.
But Salem, it won't be possible to apply it as foreign law if it's applicable under, if it's enforced in Brazil and it's applicable under Article 1, A or B.
I thought of this before
Yes.
my comment on the comment, because I imagine a case, maybe it's a hard one to find, but a case in which you have a Brazilian company, but another party to the contract that is not from a contracting state, but the private international law rule of Brazil indicates the application of a country that has CISG, that is a party to CISG. So the 1B,
Yes.
right, is possible, maybe not probable, but possible.
No, the case you mentioned is of course possible, but in my opinion, the answer is the one suggested by Professor Gamma. Whenever you apply the CSG, either by virtue of 11A or 11B, in a contracting state, you apply the CSG, even if, let's say, in your hypothetical, Swiss law is to be applied. Since the mandate comes from Article 11B, you apply the CSG as part of Swiss law as Brazilian law, meaning you can go to the Supreme Court and ask for reversal if the Court of Appeal gets it wrong on CSG. We have a lot of cases on that in Germany. So the idea is really, whenever the reason why you apply CSG is 11A or 11B, it is part of the forum's law, which goes to your point. It's important to decide because it's not foreign law anymore, even though you apply it because 11B leads you to Swiss law. So that is really the most important thing for the purpose of looking into whether you can go to the Supreme Court and to really decide this case. So the only problem is in France. I say that because, as you know, in France, conflicts of law rules are not mandatory. So the judges do not have to apply conflicts of law rules, French conflicts of law rules, mandatorily. They only have to apply it if the parties plead conflicts of laws. Of course, if a lawyer for a party does not plead it, the party is allowed to sue, happens all the time in France. But the judge is not wrong. So you can't then go to the Supreme Court and say the judge should have applied French Swiss law because conflicts of law rules direct him or her to France. That's not possible there. That's why it's important that the Supreme Court has qualified the application of CSG as the application of substantive law and ex officio. because if a French Court of Appeal gets the CSG's application wrong, now you can go to the Supreme Court. So CSG, yes. Conflicts of law rules of France, no. So that is an interesting tidbit that is around. So.
Other questions? Eduardo Gleber first, and Pedro Martini after him.
Thank you. I'm Eduardo Grebler from PUC, Minas. I was just thinking about one of Salim's comments regarding the interest of businesses to appreciate how a piece of legislation like the CISG would impact on their results. It just came to my mind a parallel. When the new Brazilian Civil Code came into force in 2002, did business people think to what extent this will impact my dealings or my transactions? Of course they didn't. That was a piece of law which only later on, afterwards, they would find the benefits or the pitfalls. In a way, I think we will be facing a similar situation where you get a new set of rules and you cannot really answer right from the beginning whether empirical data will show that you are getting a benefit out of that. There is simply no answer to that in my view. You will have to go through the process first and then find whether or not this is beneficial for your business or for the country's business in general. Now, one thing is clear, is that the ignorance about which law applies to your transaction, this has simply no price. This is the highest price anyone could pay. And I guess by getting the CISG into Brazilian law, you get rid of that cost or that lack of information that does not even allow you to know what your benefits or your damages are. This is one point I think might be worthwhile.
I could never have said it so nicely.
I think Pedro now, Pedro Martini.
This is Pedro Martini. I have a question maybe to Professor Ferrari coming out from a comment from Professor Nasser. As mentioned, there is a limitation by private international law rules in Brazil in regards to the ability to choose the law applicable to the merits. So my question, actually, I thought about two situations, is to what extent this limitation may have some influence on the ability of parties to opt out of the CISG pursuant to Article 6. Mm-hmm. I'm thinking about two situations. First, because Brazilian parties are not used to the idea of, having a say on what will be applicable when we're not talking about arbitration. And the second one is considering, for example, that many authors say that we may have an implicit opt-out when there is a choice of law, considering that judges may consider this choice of law invalid, for example. To what extent may the judge analyze that choice of law as an implicit exclusion, even if not considering the choice of law for the applicable law?
Nice. I like these technicalities. Okay, so you have to consider everything in light of Article 8, because the default rule is still CSG. So CSG applies unless opted out. Article 8 is a provision that deals with interpretation. So you have to answer your question on the basis of whether the parties wanted to exclude the CSG irrespective of the validity of the choice of law clause. That's exactly the point. Some courts have stated, if you choose to exclude CSG and then write, and French law is applicable, but whatever, let's say the conflicts of law rules do not allow you to choose French law, the clause, exclusion of the CSG, is still valid. Other courts say, no, probably they wanted to link the exclusion and the choice of law clause. This, in my opinion, answers both of your questions, but it is Article 8 of the CSG, because it's a default rule that deals with interpretation of what the parties really wanted.
Any other questions? Well, I think we are 5 minutes ahead, luckily. So thank you, Professor Ferrari, for this introductory speech. We'll be glad to have you here tomorrow during the morning and the afternoon session. Thank you, Salim, very much for your time, for being here. I know that you've been studying a lot now lately, not only public international law, but also private international law, CISG, arbitration. So I'm glad to see you in our panels as well.
Welcome to the club.
Yes.